Please refrain from drinking or eating in the courtroom. If you need to drink, just step out. Thank you.
Take a seat, please. Take a seat, please.
Now the call will commence. You can hand that up after.
Please rise. Justice of the Appellate Division, Supreme Court, First Department. Here, your person has business with the Appellate Division. Draw here, give your attendance, and you shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have a large number of cases requesting argument time today. We have almost 4.5 hours of argument time requested. Therefore, I request that you seek or ask for only the time that you need. And if we need extra time, we will keep asking questions. The first case is People versus Rodriguez, appellant. Respondent? I'll give you 5, 1, and 5. Barron versus Fuchs, appellant. Okay, it's submitted. Geraldine versus Hale is submitted. Carey versus Toy Industry Association, appellant. Is appellant not here? Do you want to just submit then? Okay, submitted. Adago versus Sai, appellant. Respondent? I'll give you 6, 1, and 6. MDRN Intelligence versus Hartford Financial, appellant. No appellant or respondent? Okay, that's submitted. People versus Bowens, appellant. I'll give you 6, 1, and 6. BBM3 versus Fosotis, appellant. I'll give you 6, 1, and 5. 176 West 87th versus Garrico. Is respondent here? Do you wish to submit?
Yes, sir.
Okay, submitted. Perez versus Twin Peaks, appellant. Is respondent not here either? 3 minutes. People versus Kingsley, appellate. Respondent? 5, 1, and 5. Riordan versus Garces, appellant. Well, actually, there are 2 appellants, I know.
Plaintiff appellants, Bigelow and Riordan, 8 and 2.
And the cross appellant? And the respondent? Okay, I'll give 6, 2, 5 and 2, and 6. Smith versus Founders Entertainment is submitted. Pigach versus Happy Garden is submitted. And Kim versus White and Case is submitted. So the first case is People versus Rodriguez.
Step up.
Go ahead.
Good afternoon, Your Honors. May it please the Court. My name is Marielle Stein, here on behalf of the appellant Alberto Rodriguez. Mr. Rodriguez respectfully requests that this Court reduce his sentence in the interest of justice by 1 year to the statutory minimum of 7 years incarceration, followed by 5 years of post-release supervision. To a man of Mr. Rodriguez's age, 1 year is a significant amount of time. He's 50 years old.
So didn't he get already, though, near the minimum sentence that was permitted, particularly considering, and wasn't that a fair sentence, particularly considering the seriousness of at least one of the 2 crimes?
Your Honor, this was 1 year above the minimum, and it was a very serious crime.
So why should the court entertain its interest of justice jurisdiction to lower to the minimum?
So first, Mr. Rodriguez, all roads in Mr. Rodriguez's life, his criminal history, come back to his drug addiction. It played a major role in this incident and the rest of his criminal record. The
You're saying
sense
that
of
just drug addiction is enough for us to lower the sentence?
no, Your Honor.
I mean, he does have a very extensive criminal history.
He does, Your Honor. However, if you review his record, the overwhelming majority are crimes of poverty, such as turnstile jumping, petty larceny, drug offenses. This court, as Judge Troutman recently emphasized in her concurrence in People v. Baugh, has a constitutional duty and power to review sentences, even when they're the result of a negotiated plea, even when...
Waiver valid here?
I'm so sorry, Your Honor.
First, you have to get over the first, you have to argue whether or not, or argue that the waiver was invalid. Is the waiver valid in this case? Because if it's valid, it really curtails, this Court of Appeals precedent, it curtails our interest of justice analysis.
The waiver is not valid in this case, Your
Why
Honor.
not?
The waiver is silent as to the nature of the right to appeal. At no point does the sentencing judge, explain to Mr. Rodriguez what an appeal is, how he can effectuate the right to an appeal, the fact that he'll be giving counsel. She doesn't do that in the oral waiver, and in fact, that's also missing from the written waiver that he signed as well. He has been told that certain rights survive, but he hasn't been told how to effectuate them. In a sense, he's been left with a right without a remedy.
Is that level of guidance required by the Court of Appeals?
The Court of Appeals has never required a specific litany. However, what it has required is that the court be able to ascertain that a defendant has understood the very important rights that he's giving up in signing the appeal waiver. There's nothing on the record here to indicate that he understands or was informed about these rights that he was losing as a result of the appeal waiver. He can't be said to have knowingly waived it when no one has told him how he could effectuate that right in the first place. So, as to the length of the sentence, 7 years is a substantial amount of time. 8 years is even longer, of course. It's the longest sentence that he's ever received. Even if this court were to reduce it, it would still be the longest sentence he'd ever received.
But isn't this a fairly serious crime in relation to the other crimes he's committed?
It was a serious crime, Your Honor. We've never disputed that.
More serious than many of the other crimes for which he's been.
Well, and 7 years would, I apologize, Your Honor, 7 years would sentence him accordingly. It's a more serious crime than his previous offenses, and 7 years would be a more substantial sentence. And he's also, once he's released, he will be undergoing an extensive period of post-release supervision when he'll be supervised by the state, but he'll also have access to the treatment that he needs. As we stated in our brief, he struggled with drug addiction for most of his life, for decades. He was only able to get into treatment in 2018. He was experiencing a period of relapse when this offense happened. That extra year of delay of getting him onto post-release supervision, reuniting him with his family, delays the prospect of his rehabilitation by delaying his access to quality treatment, the kind of high-quality, intensive treatment that he needs in order to successfully recover. The prison system just isn't equipped to provide what he needs. And it's also not—
Thank you. You'll have time in rebuttal to finish.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Jennifer Cavais for the people. Defendant's excessive sentence claim is foreclosed by his valid waiver of appeal. In any event, defendant's bargain for sentence was lenient in light of the exceedingly violent and senseless nature of his crimes. After defendant's drink was accidentally spilled in a pizzeria, he became so irrationally angry that he pulled out a knife and slashed a stranger across the face, causing an injury that required 12 stitches to close. Defendant, a second violent felony offender, negotiated an extremely favorable plea deal, pleading guilty to a reduced charge of attempted first-degree assault, and received the sentence just 1 year over the minimum, less than half of the 15 max that he faced. Defendant's purported mitigating factors posed by his struggles of substance abuse, his age, his family support were all adequately considered by the sentencing court, and imposes no reasons for this court to disturb that finding below. If there are no further questions, we ask that you affirm defendant's sentence. Thank you.
Thank you very much.
So, Your Honors, to address my adversary's comment first, this court, again, we've never contested the violent nature of the offense. This court has previously reduced sentences in violent cases and for people who were second felony offenders. The mitigation that respondent refers to, whether or not the court took it into account, doesn't prevent this court from exercising its powers. And in fact, Judge Troutman, once again to return to Ba, emphasizes that this is an extremely important oversight function that this court has. If there are no further questions, we respectfully ask for a sentence reduction of 1 year for a total sentence of 7 years with 5 years post-release supervision.
Thank you very much.
Thank you.
The next case is Adago versus Sai.
Good afternoon, Your Honors. Bruce H. Letterman for the respondents. The judgment being appealed from was entered as a result of an order at a conference on June 16, 2022.
Let me ask you a question, and this was not something that was raised by the parties in the brief, but the first question, as an appellate court, is our jurisdiction to hear an appeal. And while normally our jurisdiction is very broad, this does not appear to be a case where you have a right to appeal as a right, since it was not a motion on notice below. As you are very well aware, this was brought sua sponte by the court, and therefore there was no notice to motion. So how does the court have jurisdiction to hear this appeal as a right?
Because there was a final judgment entered. So we're...
Was it a final judgment as to all
Yes.
matters?
There was a final judgment entered. There was first a order handwritten out, signed by the judge, and a week later, it's in the record, I could find the citation, I don't have the full record with me. There was actually a judgment. So we are appealing from the judgment and the order.
Was it a final judgment of all issues in the case?
Yes, final judgment. 100%.
Okay, go ahead.
Okay. So as I said, and as the court seems to understand, there was a conference. It was listed on the court's website as just in-person status conference, which followed a decision by this court on May 26th remanding for a hearing. And on June 1st, a few days after this court's decision, plaintiff's counsel wrote a letter, which is in the record at page 313, simply writing to the court saying, plaintiff is seeking the court's advice as to how to proceed and schedule a hearing in this matter, or as an alternative, schedule a conference to discuss the matter. So counsel wrote saying they needed advice from the court on how to schedule a hearing, and then the parties appeared, and I know that counsel for the defendants had already alerted the defendants to seek new counsel, but they appeared at the hearing, and for reasons which are still somewhat baffling, the court entertained an oral motion for summary judgment based upon a representation by counsel of counsel's view. There were three very specific reasons, and there are a lot more, but three specific reasons why that order, which led to a final judgment, is incorrect. First, very simply, nothing in the CPLR allows an oral motion for summary judgment based upon representations by counsel. The CPLR 3212 is very clear that a motion for summary judgment must be supported by affidavits, by a person with knowledge and admissible evidence. And a counsel standing up and saying what he thinks happened is not an affidavit. So it's simply wrong. Second, it's both the law and also law of this case, per the May 26th decision, that there can be no summary judgment motion until issue is joined. So the question becomes, the issue was not joined, there was no answer. And the reason that there was no answer is because plaintiff's counsel never served a copy with notice of entry of this court's decision, which would terminate the 3211 stay. In this case, there was a 3211 motion, record page 57, which stayed the time to answer. This court on May 26 issued an order, but CPLR 3211F is crystal clear that the time to answer after a decision on a 3211 motion runs from 10 days from service of the order with notice of entry. It doesn't say from the order, and counsel for plaintiff, who's obviously from their briefs very savvy in the rules, should have known that. And I submitted a slip and will post on NICEF. I found last night a decision or a concurrence by Judge Heinz Radix in the Second Department, who said very specifically in DLJ Mortgage 202 AD 3rd 913 that 32...
What about the alternative argument that they were really getting a default judgment rather than summary judgment?
Well, you can't get a default judgment when the time to answer hasn't expired. And the time to answer doesn't expire until 10 days after service of notice of entry. Notice of entry was never served. Final judgment was entered, so it becomes a moot point. But they first have to give the defendant notice, service of notice of entry, not just the order, so they can't be a default judgment. So it can't be a default judgment, and there can't be a summary judgment motion because, as this court pointed out on May 26th, until an answer is filed, a summary judgment motion is premature. And finally, putting aside the incredible procedural impropriety of what went on here, there seems to be some argument that summary judgment should have been granted because there was a settlement agreement that was not performed. The settlement agreement, there is no signed settlement agreement. There was a negotiation which, according to
You know what, you have
plaintiff...
time to respond to this on your rebuttal.
Okay, thank you, Judge.
Thank you.
Judges.
Good afternoon, Your Honor. Bernadette Panzella for the plaintiff respondent, Roberto Adago. I would like to start by just saying that this court on May 26, 2022...
Counsel, why don't you actually address the primary issue on this appeal, which is the authority of the court to grant summary judgment in this situation when there was never any motion, and the court basically sua sponte made a determination to grant summary judgment when there was no pending summary judgment motion before the court.
Okay. Your Honor, in this case, I would like to actually quote to the court this court's 2018 decision in the case of Gramercy Park Residence Corp., where it says that the Supreme Court is powerless to change or remit it from this court. Nevertheless, in order to avoid an obviously unjust result, it may mold its procedure and adopt its relief to the exigencies of any new facts. Here, the new facts was that the defendant was in default of answering the complaint because, contrary to what plaintiffs, defendant,
the court did describe it as a summary judgment determination, not as a default, but either way, whether it was a default or it was summary judgment, I know you cited that case, which has some very broad language, but how does the court have specific authority under the CPLR to decide either a summary judgment motion or a motion for default in the absence of an application by the party? Because there's certain requirements about putting the party on notice, entertaining argument on it, none of which occurred.
Your Honor, because the defendant respondent was represented by his longtime counsel who consented to the hearing court charting a summary judgment course. As a matter of fact, the defendant respondent's attorney, Mr. Cuccio, has not submitted any papers before this court, and he actively participated in the hearing. He participated to the extent where he participated in drawing up the order. The motion court asked him questions about his client, why the payments were made. He participated in jointly submitting
Let me ask you,
order to the court.
There's clearly authority to convert a motion to dismiss into a motion for summary judgment with the consent of the parties, but I'm not aware of any authority of converting no motion into a motion for summary judgment on the consent of the parties, because then what's the record?
Most respectfully, Your Honor, in this record, in the counter statement in lieu of transcript, it is very clear that the attorney for the defendant respondents fully participated to the extent of retaining his client's right to get a 40,000 euro offset for partial payments on this $750,000 that he defrauded Roberto Adago from. With the consent of the defendant respondent's attorneys, the court, in the light of all the evidence, based on the application of plaintiff appellant's counsel, agreed to go forward.
Counsel, you're making these arguments here. Is there maybe I overlooked it, but was there a transcript of these proceedings?
No, there was no transcript.
So you're making these arguments about consent and what was going on. It's really at a point where I can't, I'm a person who likes to look at the transcript and see and read for myself what went down and what was being argued. All this is sort of your sayings this happened, correct?
No, Your Honor, it is not, respectfully. At page 319 to 3, let me give this to you the exact, 319 to 329 of the record, there is the counterstatement, CPLR 5525D counterstatement in lieu of transcript, which the motion court, the hearing court, so approved. Your Honor, we made a motion in the beginning. We agreed to to forestall collection proceedings in the beginning of this action, of this appeal, pending the outcome of this appeal. We did cross-move, though, because the defendants failed to put in the CPLR 5525D statement in lieu of transcript. This court, in an August 30th, 2022 order, granted our application to strike the defendant appellant's record and brief because they did not put this statement in. So this statement of exactly what transpired at the hearing court, before the hearing court, was signed by the justice who held the hearing. So this is just not me saying this, Your Honor. This is not anybody saying it. On September 16, 2022, the Honorable Susan Adams signed off and so approved.
But that goes to my colleagues, point, that if we were to agree with you, then there will be no need for motion practice. The court in itself can just grant summary judgment when it decides that it was ripe, or that in the interest of justice, so to speak, that's the right opportunity to do that. That would be kind of contrary to what we have established in the CPLR.
May I, Your Honor, if I may have a moment? In the case of Gramercy Park residents, which I just cited, this court said that if there is new information, it would be unjust to ignore that new information. The new information was the default in answering...
Was that teed up for a motion for summary judgment, though, when you say new information? What was the procedural posture of that case? Because I don't have it in front of me. What was the procedural posture of that case?
Well, this says the Supreme Court is powerless to change a remitter. Their position is that this court remitted for a hearing certain specific issues. What I am suggesting, and based on this court's rulings and holdings, which also cite to the Court of Appeals, it says that if there is new information, it would be an abuse of discretion on the part of the motion court to ignore that information. So here we have someone who admits, even today, doesn't deny in any papers before this court, that he owes this money and hasn't paid it back, that he absconded with this money and used it for his own personal use to try to avoid two different foreclosure proceedings. And I would respectfully...
No, I'm going to interrupt you now because your time is up. I let you finish up the thought, so thank you.
Okay, can I just finish up the one thought about the Court of Appeals? Where the Court of Appeals says that it would be, and this court quoted the Court of Appeals, it would be an abuse of discretion for the motion court to ignore this new information, and it would end up then in an unjust result. And the case is that...
Thank you very much, counsel.
Okay, thank you.
I think the court understands the issues, but just to address a couple of things very quickly. The new information they're talking about, they claim is a default. As I said, under CPLR 3211F, there was no default, and it was their own fault because they didn't serve notice of entry. Second, the cases which they cite, which talk about courts charting their own course, had to do with timing for posting a bond where there was no specific CPLR section that dealt with it in one case. It had to do with posting a bond. It had nothing at all to do with a court entertaining a summary judgment motion, I believe, as two of the judges have brought up. There's just nothing in the CPLR that allows an answer.
Well, sir, along those lines, at the June 16th, 2022 appearance, did you or your client acquiesce to a summary judgment type course?
Absolutely not. We submitted, there was no transcript. We submitted a statement in lieu of transcript that said that there had been an objection. Counsel submitted their own statement that recited that. For whatever reason, the same judge who made an error signed their statement in lieu of transcript. They didn't ask for a transcript. I can represent to the court that counsel did not in any way consent. Thank you.
Thank you. The next case is People versus Bowens, I'm sorry.
May it please the court. My name is Nicolas Quaid Galvan. I'm a former Columbia Law School extern with the Center for Appellate Litigation and now a pro bono law clerk at Patterson, Belknap, Webb, and Tyler. I represent appellant Jimmy Bowens. There are two issues regarding the Hinton hearing. First, right after the undercover officer testified at the Hinton hearing that she used the judge's private entrance for her own safety, she was seen walking out of the courtroom's public entrance. This seriously calls into question the undercover's credibility because she testified that she entered through the judge's chambers because she, quote, didn't want to be seen by the general public, end quote.
Sir, why is it not plausible that as was developed in the record, that the undercover officer was confused by the maze of the corridors and hallways, and believe me, having been down there, it was confusing for me for many years. Still confusing for me. So why do are you making light of that confusion and the officer's desire to somehow figure a way out of the building without in any way compromising her position that she was concerned for her safety?
Well, yes, Your Honor, it's completely plausible that the undercover officer simply got lost, but in People v. Tolentino and People v. Parker, this court found that the trial court is prohibited from, quote, solely relying on the prosecutor's representations. Here, we relied on the undercover and the prosecution's representations that the undercover officer got lost. This falls short from testimony under oath. And if the Hinton hearing was reopened, defense counsel would have had an opportunity to cross-examine the undercover officer. That did not happen here. This seriously calls into question the undercover officer's credibility, and we had a good—
Can't the court use its own knowledge of how confusing the courthouse is in making its determination whether or not it was reasonable, required to reopen the Hinton hearing? Especially when there was ample evidence in the record that the undercover was trying to keep her identity secret.
Yes, Your Honor, the court may use that own information, but in People v. Tolentino, the appellate court found that the trial court abused its discretion when it refused to inquire why an undercover officer was waiting in the public hallways of the courtroom. Presumably there, the trial court used its own information to—
Isn't that different than how you exit from the back of the courtroom where the judge has knowledge that the courthouse and the back exits are confusing? Isn't that different than just hanging out in the hallway before testifying?
Absolutely, Your Honor. It is a little different. But what connects Tolentino and Parker to our case here is that the trial court below solely relied on the prosecution's representation. It had a duty to inquire on itself why the undercover officer exited through the public entrance. We could have asked the undercover officer, why didn't they just wait by the door till the next person came out? Maybe the undercover officer could have waited for 10, 15, 30 minutes, who knows? But the trial court below had a duty to inquire into those reasons.
If I may, I want to go back to Tolentino.
Yes.
Because in that case, the officer was waiting in the public hallway. So certainly that officer made a conscious decision in spite of whatever testimony they may have provided. And here, we have something that appears to be inadvertent, accidental, in light of everything that my colleague said. So how is that contradictory to the testimony of all of the things that the officer did to protect the identity? Because I see it as being very different.
Well, Your Honor, actions speak louder than words. The sole reason that the undercover officer wanted to close the courtroom was to protect their identity. And we simply do not know if it was an accidental exit through the public entrance. We could have found out those reasons if we developed the record.
She was confused. She said that. She was confused, and the prosecutor provided that information to the court. And that's much different than just sitting in a public hallway waiting for a case to be called.
Absolutely, Your Honor. And in that case, and if that was the case and we reopened the Hinton hearing and heard directly from the undercover officer themselves, then yes, that may have been enough. That may have been okay, but we just simply do not know because we did not get this information directly from the undercover officer. The trial court below solely relied on the prosecution's representations. But Mr. Bowens' right to a public trial was also violated when the moment his family was barred from the courtroom unless they agreed to it.
Counsel, they weren't barred from the courtroom. As I understand on this record, there was a screening process in place that would have fully permitted any family member as of right to attend, as long as there was no connection in some way with the family enterprise, and I'm being colloquial. We recognize that your client, the defendant, and his brother were in business together. They lived in the apartment with their father. In fact, when your client was about to be arrested, he was concerned about his father's health. If I'm not mistaken, there was an emergent situation. It's kind of like a family scenario, and it's a communal scenario as well. So there's no case law that I'm aware of that would ban appropriate screening processes that would ultimately have allowed as many of the family members to attend if they went through that process. And in my understanding on the record, nobody showed up, correct?
Your Honor, the record is unclear on that fact. We do not know if anybody showed up, but in the Court of Appeals—
Nobody was barred, though, right?
It is unclear, but in People v. Jones, the New York Court of Appeals found that a screening procedure is a closure even if nobody is denied entry. This is because the right to a public trial is implicated at the moment of the screening procedure is put in place.
Thank you. You have time to rebuttal.
Thank you, Your Honor.
Good afternoon, and may it please the court. Faith Petrolio for the people. Defendant's conviction should be affirmed. Defendant does not contest his sale conviction and his possession convictions comported with the weight of the evidence. Defendant admitted that he lived in the house with his brother. He was captured on video talking about selling drugs to the undercover officer while his brother sold the officer cocaine. He regularly texted the undercover officer regarding selling drugs, and most importantly, defendant sold the undercover officer drugs independently. He was the only one home when he sold these drugs. So clearly he had constructive possession of the drugs and the paraphernalia, and so his convictions comport with the weight of the evidence. Turning to the Hinton hearing, as defendant does not contest, there was more than sufficient evidence to support the general public's exclusion from the courtroom during the undercover officer's testimony.
Why shouldn't his argument be accepted that the court should have opened up the hearing again to find out what the confidential informant's real reasoning was for going out of a public exit?
Well, the information that defense counsel presented the court that the officer had used the public exit on her way out of the courtroom was not a material fact that would have changed the outcome of the hearing. As this court has noted, the officer testified at the hearing that she went through many steps to protect her identity. She was wearing street clothes. She didn't travel with other officers. She didn't travel in a marked police vehicle. She used the non-public entrance to the courthouse. And so her confusion in exiting the building does not undermine those facts. So the outcome
Counsel, aren't we basically then assuming that it was confusion? I mean, that's one inference. Another inference is she just wanted to leave the building and she wasn't that concerned for her safety, so she went out the most convenient exit. And wouldn't that be, as Judge Kern was indicating, wouldn't that be supportive of your friend's position that she wasn't as concerned about her safety as perhaps she testified in the Hinton hearing itself?
Well, the prosecutor did inform the court that he had spoken to the undercover officer and that she had used the wrong door going out of the courtroom, and I think it locked behind her, and so she was stuck, and so ended up having to use the public exit. But additionally—
Is hearsay permissible at a Hinton hearing to support the closure of the courtroom?
Well, Your Honor, the Hinton hearing did not need to be reopened because Hinton just requires that an inquiry be made. And here the court did make an inquiry to the defense counsel and to the prosecutor about the situation and about the new facts that were before it. And so it concluded properly that the hearing did not need to be reopened. As it noted, the record sufficed to support the closure of the courtroom, and the Hinton hearing did not need to be reopened in full. Additionally, the screening process that was implemented by the court was proper. So courts are allowed to implement screening processes for various reasons. The one here was very minimal. It just required the provision of a few pieces of information to the court. And most importantly, the people were not going to have the final say and determination as to who was barred from the courtroom and who was let in. The court was going to have to go on the record and about if it was going to exclude these family members or not. As it noted, the people would have to make a particularized showing before anyone was actually barred from the courtroom. But as the court noted, no one was actually barred as a result of this procedure. The record does not have, there is no portion of the record that contains any evidence that the court did hear argument as to whether certain family members should be admitted or excluded from the courtroom.
Have we ever approved or endorsed a screening procedure such as the one that the trial court employed here?
Yes, I think there are multiple screening processes that are very similar to the one here. I think those are in the cases in the brief. To address the Jones case, I believe the Court of Appeals in that case was very specific that it was talking about the screening process in that case. So it said the screening process here implicates the right to a public trial because it has the same, it implicates the same secretiveness and fairness questions that come about with a total closure of the courtroom. In that case, the procedure was a court officer standing at the door of the courtroom and sorting people based on why they wanted to come into the courtroom, which is very different than the case here. Just to turn to defendant's motion to sever, it was made well past the time limit. It was untimely, and defendant, with due diligence, could have found out that information to provide him with good cause to extend the time period. And excuse me. At the end of the day, the defenses that were presented at trial were not antagonistic, and so there was no danger that the jury could have inferred defendant's guilt from any potential conflict between these two defenses, and in any case, the error would have been harmless. I mean, defendant was acquitted of all the jointly charged sale charges in this case. If there are no further questions, we ask that you affirm.
Thank you very much.
Your Honors, even when a courtroom is properly closed to the general public, the presumption is that family members can enter the courtroom. And here, the prosecution barred the family members from entering the courtroom unless...
Counsel, wasn't there actually a basis for in this case because the two brothers were alleged to be involved in this business together and the father was cohabiting with them? Didn't that provide a reasonable basis for the court to create some kind of screening process to address that particular concern in this case?
Yes, it provided a basis as to close the courtroom to the general public, but once the defense wants to...
The specific concern was about family members also being involved in the drug business who lived in the house with the defendant, and there was a confidential informant who was testifying who they were trying to preserve the identity of. So under those circumstances, wasn't there a reasonable basis for the court to institute this procedure?
I see my light is turned off, but I'll answer the question. Not in this case, Your Honor, because each family member has to show that there's a substantial, the prosecution has to show that each family member has a substantial probability to be a threat to the undercover officer's safety. And when asked if the undercover officer knew anybody in the Bowens family beyond the brother, the undercover officer stated, quote, "I do not know any family members," end quote. And then she speculated that Mr. Bowens had a, quote, a mother, a father, it could be an aunt, and it could be an uncle.
Okay, thank you, and thank you very much for your pro bono assistance in this.
Anytime. Thank you, Your Honor.
The next case is BBM3 versus Fosotis. Yes, you should be sitting over there. Go ahead.
Good afternoon, Your Honors. Are we ready? Yes? Okay. Brian Grafman, Bora Goldstein, for defendant appellant James Fosotis. I'd like to address three issues. First, the completion guarantee under CPLR 3213.
Well, before we get to the merits, don't you have to deal with that you're not coming to us de novo, that this is a motion to renew and re-argue?
Well, okay.
Isn't that the first hump that you have to get over, why these issues weren't brought up in the first instance, and instead
I have the answer to that.
imposed in jurisdiction?
Yes, Judge Kern. The plaintiff had to make its prima facie case on whether the instrument qualified under 3213 as whether opposed below or not, and this court said so in 27 West 72nd Street, a case that plaintiff cites.
Isn't the context that it's coming up on that they made their motion, you didn't oppose on the ground that they didn't make the judge made a decision, so when you come to the court, the first thing you have to do to even be heard by the court is win your renewal argument, why the court should entertain renewal.
It's not on the 3213 issue, it's the issues here on appeal twice correctly. One, plaintiff on 3213 has to make a prima facie case.
Right, but you're not appealing the original decision.
This court already said, in the case they cite, that even if it's not opposed below, that's what this court said.
I know, but we only decide the issues that are properly before us, and if you never appealed from the initial determination.
We did. We appealed from the judgment, and we secondly appealed separately after the fact from the re-argument because the judge below addressed it on re-argument, and when you address it on re-argument, it's properly before this court. So there's double, it's here before this court, validated twice. Okay, now it's on the jurisdiction. Now, on the merits, the judge below cited three cases, one on a $10 million simple loan, and the other two based on federal judgments, which unquestionably is enforceable under 3213. The completion guarantee here involved payment and performance of assorted tasks requiring reference to a plethora of documents and estimates at page 276 in the record, the design, the construction, the completion of the project, which may be updated and amended.
Can you just explain that? Because there has been a development in the law in terms of what constitutes an instrument for the payment of money only. And even if there are other conditions in the guarantee, as long as the requirement to pay money is unconditional, then it's an instrument for the payment of money.
Right.
Why was the completion guarantee not stripped of its essence, required the payment of money separate and apart from any conditions?
If you have to deal with complex agreements and estimates and Byzantine, you're not going to find the numbers here. If you look in the record, you can spend your time to do so, as I have. If it's more than a de minimis deviation, it's not an instrument for the payment of money only under the expedient of 2213. That's what the court has decided. The cases we cited 23 of our brief, including PDL and Punch. Moreover, our client disputed the performance allegations and the estimates on which the amounts are based at 433 of the record, although he didn't have to at this stage, because as stated, this court has stated in the case I mentioned, 27 West 72nd Street, you don't even have to oppose it. If it doesn't meet it, the court has jurisdiction. I'd like to turn, if I could, to the compound interest issue. That, too, again, is part of plaintiff's prima facie case, can be determined on appeal from the judgment, and as a matter of law, and although, anyway, we did present the alternative that it might include a question of fact, which I think not. Plaintiff admits a compounded interest. It's in the motion. When the court gets the motion and sees at page 314 in the record, daily compounding, the court should know that you shouldn't, you don't compound, and they don't dispute our cases that say you don't have a right to compound unless there's an express agreement. I'd like to turn to the renewal and re-argument issue.
Mr. Grafman, I'm confused, so let me take a step back. It is my understanding on this record that the motion practice before the court, the defendant focused, as I understand it, and you can correct me, solely on the issue of whether there was personal jurisdiction. Because Delaware, Texas,
correct,
beautiful charts and
that was
lines.
A mistake.
All nice, just bear with me.
Counsel.
There was no affirmative motion arguments to challenge the interest and carry guarantee, the completion guarantee, to challenge the merits of the 3213 motion that the plaintiffs were seeking to enforce.
Correct, it didn't come
Just
till the
bear-
next motion.
Give me a second. As I understand it, now we're up on appeal, and on that, as you said, and also on the issue of re-argument and renewal, and it's my understanding, and please correct me, that you're not challenging re-argument, because your reply brief made it clear you weren't challenging the denial of re-argument. As I understand it, on your brief, page 89, note 1, you're challenging the denial of renewal. And renewal means when you get new information that you couldn't possibly bring on earlier for whatever reasons, and I'm being colloquial, but you understand what I'm saying, then under 2221, you don't get that bite of the apple. And since the lawyer below who made that first motion to challenge the jurisdiction made none of these arguments, and they had a full and fair opportunity to present all this information because they had knowledge of it all, how can you possibly come here and say they're the basis for error in denying renewal?
Okay, there's two reasons. Because if the judge addresses it on renewal, there's jurisdiction. And secondly, we go for the exception that says, if in the interest of justice, remember the judgment here of $19 million against an individual is mostly compound interest, it's mostly interest here. That's at page 38 of the record. And the difference between compound and simple was over $10 million as of the end of 2021, page 863 of the record. We cited the page before it, actually it's more than 10 million. So there's no dispute that they are compounding interest. And the CPLR 104 says that you could construe the CPLR liberally when interests of justice are at issue.
Any more questions? You're going to have time on rebuttal.
30
Is there
seconds
any more
more?
questions? You'll have time on rebuttal. You have time on rebuttal. Are there any more questions?
There's one issue I
Okay.
just...
No, you'll have time on rebuttal. It's okay.
May it please the court. Mark Kaufman from Kaufman & Kahn on behalf of the respondent, BBM3. The panel seems to understand that this is procedurally a difficult place for the appellant to be bringing this case. The court need not consider any of the purported merits of the appeal because the appellant failed to oppose the motion for summary judgment in lieu of complaint. Rather than filing any opposition, the first attorney cross-moved to dismiss for lack of jurisdiction, so the appellant failed to raise any questions as to the completion guarantee or as the interest and carry guarantee. They didn't dispute any of the amounts here. They had fair opportunity to do so. They also failed to bring a proper motion for reconsideration. If this was a motion for re-argument, they have waived that, and appealing a denial of motion for re-argument is not appealable. If the motion was for renewal, the only justification that the appellant has for failing to raise the issues in opposition to the summary judgment belatedly is that the first attorney was negligent and failed to raise these issues in opposition. They do not suggest that any of these facts or documents were unavailable to the first attorney. The attorney negligence in a civil or commercial case is not a reasonable justification to merit renewal. This is not law office failure. This is not missing a deadline. This is not an incapacitated attorney. Rather, it's an attorney who made a poor judgment call and didn't use the strategy that later attorneys would find beneficial to the client.
Sir, at least part of your friend's argument, as I understand it, is that regardless of whatever arguments his client made on the underlying 3213 motion, the court should have scrutinized the plaintiff movant's papers to ascertain whether he made a prima facie showing, and that prima facie showing was wanting for, among other reasons, we didn't have an instrument for the payment of money only.
Two things. One, it's certainly not the obligation of the court to scrutinize this, and yet the judge did go to the trouble of looking at the underlying document and finding that the completion guarantee is not void as an instrument for money only, merely because it says the word obligation. This court has held in the same case, I believe that my colleague is relying upon, that merely adding the word obligation does not change the underlying irrevocable, unconditional promise to pay money, particularly when the sentence ends as it does in this guarantee, with the words as and when due and payable. Here, the demands for money and the guarantee itself only sought to get payment of the obligations underlying in the loan agreement. As for the interest and carry agreement, the interest was not compounded. It was, in effect, interest on interest because the interest and carry guarantee was requiring replenishment, or the loan agreement itself was requiring replenishment of an interest reserve. Unpaid interest of the $4.6 million that initially started in the reserve could be charged, and interest would be charged while waiting for that reserve to be replenished. As for the unjust or the purported reliance on whether this is fair or in the interest of fairness and justice, this is an appellant who didn't pay a dollar of a $38 million loan or any of the guarantee of a $38 million loan. Instead, the new lender in the form of the respondent paid all of it in order to get rid of the first lender. It would be
Well, that goes to the renewal. That's one of the arguments that he raises in the renewal, which I agree. I mean, conceitedly, that should have been the first time what had gone around was your client or the person who was the assignee of this loan called the loan because, you know, he wanted to grab all the interest. That's the allegations in the renewal aspect.
It is.
I just want to put that into context when you're saying that.
Certainly, but he also went out of pocket, or the entity went out of pocket $38 million.
Yeah, but he's got a hotel too now. He's got a Miami Beach hotel.
Well, yes, which isn't
Okay.
free to operate either.
Yeah, I read the record. Okay.
As for the interest and carry, it was an appropriate means of doing this. And this court has also found specifically in LFR Collections versus Bland Law Offices that where the appellant failed to explain why they did not previously argue that plaintiff improperly compounded interest, the court should still deny that motion to renew when, in a very similar context, the appellant did not contest the motion, did not oppose the motion for summary judgment in lieu of complaint. Thank you, Your Honors.
Thank you very much.
Okay, real quickly, that case he just cited, the LFR collections, which they cite, that rejected the compounded issue on renewal, but that was dictum because the court did address it. Plaintiff denied compounding there, and plaintiff here concedes compounding at pages 25 and 26 of their brief. Judge Oingen, you mentioned about the calling the loan to take over the hotel. There's in the record here, there's, remember, there's a related agreement, which is the hotel's operating agreement, that says you can't take any act to adverse to the hotel. And here, they stole, the principal of plaintiff stole PPP funds. That's in the record at page 13, 804, and 837. He refused to allow the hotel to reopen.
Yes, well, counsel, the problem you have, this is all on the renewal motion, right? This wasn't on the main motion. I mean, if there was the motion in chief, you know, who's to say how this argument would have, who's to say how the case would have proceeded? But
again,
anyway,
we recognize that is an issue, but again, this is an unusual case where this court shouldn't be participate in their fraud to take the PPP funds, close the hotel, and perpetrate a fraud as an instrument to breach the contract and fiduciary duty and the public policy at play as well.
Thank you very much. Perez versus Twin Parks.
Good afternoon, Your Honors. May it please the Court, my name is Melissa Lenowitz of the Law Office of Stephen H. Franco. We represent the plaintiff appellant Ramon Perez. We are seeking the reversal of the denial of plaintiff's motion for summary judgment. The central issue of this appeal is that the reasonableness of the placement of the warning sign is an issue of comparative negligence, which is not a bar to summary judgment. The evidence of defendant's negligence was compelling and overwhelming. Thus, the Supreme Court correctly held that the plaintiff made a prima facie case of liability as a matter of law and that the defendants created the defective condition that caused Mr. Perez's injuries. However, the Supreme Court
Counsel, putting aside whether, putting aside whether the plaintiff was comparatively negligent in holding the gift box and not seeing the first sign that was wet, you know, the first warning sign on his floor as he descended the 2 flights. Isn't there other information in the record that has nothing to do with comparative negligence as to whether the floor was actually wet? I mean, I know your client said his pants were wet, et cetera, but we know that the floors were mopped about an hour before the accident. And one of the issues is whether it dried up, you know, unless there was a total flooding, you know, of the pail of water, you know, in cleaning the stairwell. So, I mean, aren't there other factors that suggest that there are issues of fact that in terms of countering your client or your prima facie case, in addition to the protocols that the defendant put forward in terms of this is how we do things. We put the sign down at the various entrance points, and the reason there was no sign at your particular point of the accident was because that was an emergency exit, and all that stuff. Wouldn't that create an issue of fact here?
No, Your Honor, it doesn't create an issue of fact because the plaintiff actually testified that he could see where he was going even though he had the box that he was holding, that he was looking down and to his right and his left, and he could see the steps 3 to 4 steps ahead of him. That was the first thing. Being the second issue with regard to the floor being wet, that's completely speculation on the part of the defendant. The defendant's superintendent actually testified that the floor was wet, that the porter never came back to dry it, and that it was wet even over an hour later when the plaintiff was seen slipping and falling down the stairs on the videotape.
Counsel, if I may, I believe it's page 11 on the brief where you acknowledge that the plaintiff walked past the wet floor sign as he descended, and going even further, the video shows him walking past the sign. So how do we deal with these facts?
That is true, Your Honor. However, in Zubalaga, this court held that a plaintiff that walked past the first wet floor sign and then proceeded to fall, and after he fell, he first noticed that the floor was wet and that there was another wet floor sign up against the wall that wasn't standing erect, and that was held to be go to comparative negligence as to the reasonableness of the warning sign.
Thank you very much. Is there any other questions? Thank you.
Thank you.
The next case is People versus Kingsley.
For Mr. Kingsley, the Legal Aid Society by Anju Alexander. Good afternoon, Your Honors. Mr. Kingsley established by a preponderance of the evidence that he suffered from a debilitating physical condition, the extreme loss of vision in his remaining eye, that the SORA court recognized was a mitigating factor which reduced his risk of recidivism. The court noted that his condition was compelling and has significant impact on his risk of reoffense. And
so when he committed the offense, though, which is creating this SORA determination, wasn't he also legally blind at that point? And didn't that have no impact on his ability to reoffend?
So the record shows that he began experiencing a decline in his vision beginning in 2015. What had changed from that time up until the SORA hearing is that 2.5 years after the underlying incident in this case, he was diagnosed with end-stage glaucoma, which is effectively a profound loss, nearly total loss of vision. And so the circumstances—
Can't we take away from this that he has ability to commit these offenses even with impaired vision or lack of vision?
The distinction drawn by counsel at the SORA hearing was how significantly his disease had progressed since the underlying incident in this case. So over 2.5 years later, he was diagnosed with the end-stage glaucoma. It had completely changed his condition. It made him reliant on eyeglasses, a visor, and a cane to navigate spaces. While incarcerated, he required special accommodations. While he showed up in court, he had to be uncuffed for his safety. So yes, the decline in vision had been happening for some time, but there was a change in circumstances in the last 2.5 years or so preceding the SORA hearing that was directly at issue over here.
I'm sorry, counsel, I'm not sure if my colleague raised this earlier. He was legally blind before he committed this offense.
So, Your Honor, my understanding is that he was
And that blindness obviously didn't prevent him from committing this offense, correct?
the record shows that he was found to be legally blind, or that he was experiencing a decline in vision beginning in 2015. So yes, that preceded the incident in this case. What has changed since the incident in this case?
I understand you mentioned the end-stage glaucoma, but legally blind is a disability. He's entitled to all kinds of benefits by being legally blind in terms of equipment, et cetera, et cetera. It's a serious disability. So the point is you're relying on a very disability to downgrade from 3 to 2, which was in place, the disability, before he actually committed this offense. Moreover, he has a history of committing sexual offenses against children, which is a real danger here, which arguably you don't really, I know I'm running on a little bit, you don't really challenge the upgrade to 3 from 55 points, you just want it downgraded because of the disability. True?
Right,
So the whole backdrop, the whole concern that the SORA court has is not your issue here.
The concern that the SORA court has was addressed by counsel, but primarily because, as Your Honor notes, because of his disability, he requires access to certain supportive services. And what the Level 3 does is it triggers restrictions on his housing and his travel under SARA. And so counsel's argument in support of the downward departure to Level 2 was primarily on the basis of the fact that SARA would now keep him from appropriate housing given his disability. It would also keep him from important services that he had access to.
How do we weigh this against, this is not a case where there was just one offense. He has a long history of sex offenses, so which would increase the chances of another incident occurring. So how do we balance that against what you're arguing, his ability to find housing?
Understood. And Your Honor, I would note that defense counsel did not dispute the RAI score here, which takes in part his criminal history. So under Factor 9, Mr. Kingsley was scored 30 points. He received a total RAI presumptive score of 55 points, a low Level 1, and counsel did not dispute that he's subject to the override to Level 3. But as the guidelines recognizes, an objective instrument like the RAI simply can't account for the nuances of every possible SORA case. And this is precisely the sort of unusual situation that a downward departure is supposed to account for. I would just note this—
Counsel, if I may, because I know that the judge, she did request of the parties to further investigate, right, if there were any other protections that would allow the defendant to access appropriate supportive housing. Am I correct about that?
What I believe Your Honor is referring to is that the hearing began in October of 2021. Following that hearing, the court asked for additional submissions from the parties to see if there are some special sort of precautions the court could navigate that simply is just not available under the facts here or under how SORA adjudications work. And so what defense counsel did provide the court with was with information about precisely the kinds of effect Sarah would have on Mr. Kingsley and what that meant for him going forward. The council also noted that as a level 2 offender, he's still subject to lifetime annual registration requirements. His information is still publicly available in a database for community notification purposes. And so the concerns about public safety are adequately addressed as a level 2.
And I'm glad you said that. Justice Kern, if you could just allow me, because the court also indicated that the defendant had committed sex crimes against young girls in public places and shouldn't be allowed anywhere near schools and libraries. So if we go back to 2001, at the SORA hearing, he was already designated, I believe, a level 3 because he had sexually abused a 9-year-old girl in a New York public library.
That was the court's concern, and I acknowledge that it's the concern of the panel here. I would just note that the SORA court did not disagree with defense counsel that Mr. Kingsley's condition was compelling, that it would impact his risk of reoffense, that the court recognized that his circumstances had changed since the underlying incident, that the 2.5 period between the incident and the SORA hearing had resulted in further decline of his vision, and also the court recognized that this was a compelling reason to downwardly depart. It's just that in an exercise of its discretion, it decided not to, and Mr. Kingsley is respectfully requesting that this court recognize its own, exercise its own discretion and depart to a level 2.
Thank you.
Good afternoon, Your Honors, and may it please the court. Stacey Nadell for the people. The SORA court properly adjudicated defendant a risk level 3 sex offender and correctly declined defendant's request to downwardly depart from that level. As the panel and the SORA court noted, defendant is the exact kind of offender that the SARA restrictions and the SORA restrictions together are aimed at targeting, essentially.
What about the particular issue in this case, which is somewhat unique, which is that his eyesight has deteriorated so much that it's going to be very difficult for him to find appropriate housing if he remains a level 3 sex offender. How should that factor come into play in this case?
Yes, Your Honor. The people don't contest that defendant suffers from a debilitating eye condition, and neither did the SORA court below. And as the panel noted, the SORA court engaged in a very careful and thorough balancing test, taking into account supplemental briefings from both parties related to defendant's eye condition and also the public safety concerns. So while we're not contesting that defendant has a very serious eye condition, his vision started deteriorating in 2015. So it's been a while, and he was diagnosed as legally blind in February 2018, which was just 8 months before the underlying conduct of the instant crime. So defendant is clearly suffering from this condition, but it's not preventing him from the criminal behavior that we're addressing today. And the SORA court recognized that and ultimately decided that the defendant should not be adjudicated anything less than a risk level 3 because he should not be located within 1,000 feet of a public library, of schools, of anywhere where he can have contact with children specifically, which he has an extensive history of harming. In 1999, he, as the panel noted, in 1999, he sustained a felony in North Carolina for having sexual contact with a 9-year-old girl in a public library. And just 2 years later, the same thing here in New York. And in 2016, which was only 2 years before the underlying crime in this case, defendant was convicted for a multitude of different sexually based offenses for having sexual contact with a 13-year-old girl. So the SARA restrictions are aimed at preventing this kind of conduct and preventing anything like that from happening again to the public. And again, the SORA court had all of this information, conducted a very extensive and thorough balancing test in order to determine that despite defendant suffering from a long-term progressive debilitating eye condition, his conduct was just so egregious, and he has a history of it, and the likelihood of him reoffending is high, and the harm that he will inflict upon reoffense is also high, and that substantially outweighed in the SORA court's opinion and what this court should find here today is that the harm that would occur upon reoffense substantially outweighs the mitigating factors that defendant put forward. If there are no other questions, we ask that this court affirm the order of the Sora Court.
Thank you very much.
Thank you.
Your Honors, I'll address any questions from the panel if there are any, and if not, I'll rely on my brief and my reply. Thank you.
Thank you very much. The last case is Riordan versus Garces, and Justice Kennedy is recused from this matter.
Helen's over there.
Good afternoon, and may it please the court. David Lynn of Lewis and Lynn on behalf of the plaintiffs' appellants, Bigelow and Riordan. The Supreme Court's decision that the statements at issue did not charge plaintiffs with a serious crime was wrong on two levels. First, it did not view the full context of the statements, and second, it did not apply the correct standard. Now, the parties, the respondent and the plaintiff appellants, agree on 2 points. First is that Lieberman versus Gelstein, which was relied upon by the Supreme Court, the case was from 30 years ago. It did not provide a specific definition of serious crime. And the second...
Didn't it find, though, that a threat to kill someone is not a serious crime because it just constitutes harassment under New York penal law?
Right, it did find on those facts
Isn't it applicable that a mere, and I know there are other things in this case which you can discuss, but a threat to kill someone by itself is not a serious crime under New York law?
Well, a threat to kill someone by itself in that context would not be a serious crime. Lieberman is controlling precedent. However, the second point is that we do have to view the statements in their full context, and that was a subsequent Court of Appeals case in Armstrong. And here, the court took these 4 words, threatened to kill me, basically out of context and did not look at the full context of the statements. Full context of the statements.
What's the serious crime you're alleging has occurred in this, was alleged in this case?
Well,
since you've acknowledged that just a threat to kill is only harassment, what are you alleging?
Well, there's a multitude of federal statutes that we could point to, and some state statutes as well. The federal statutes, there's 3 of them. They all concern threats on federal property.
Are they assault cases? Is that what you're referring to?
Assault or stalking cases, threats made on the territorial jurisdiction of the United States, including simple assault.
Okay, so what's the distinction then between a simple assault under 18 U.S.C. 113A5 and the harassment that was found to be not sufficiently serious in Lieberman?
Oh, I would say, given the context of these acts alleging to have happened on federal property, that brings it into a federal crime, and the federal penalties for such crimes are much more serious.
So you're saying the mere fact that these alleged acts occurred on federal property is what transforms it from not a serious crime into a serious crime under New York State defamation?
No, I wouldn't say that solely, because the statements in context include statements in addition to just the threat to kill. There is also a charge that essentially they were spitting and invading a personal space. So that brings the statements beyond what was charged.
If someone was brought before the New York criminal courts for spitting, what would happen to them? What would What would be the serious crime they'd be charged with for spitting at someone?
I think that could be assault. It could be assault under the federal statutes as well. So the point is that the statements, when viewed in their full context, the defendant made an effort to emphasize the dangerousness of the plaintiff appellants and emphasize the serious consequences that would be that should be brought upon them. He emphasized that he called the federal authorities, including the Federal Protective Services, to report this crime. So in the full context, we're looking at more than just what happened in Lieberman, but a situation where the defendant consciously did what he can to emphasize the serious nature.
Well, let me ask you, part of what we do in these cases is try to look at the gravamen of the claim to determine what's really being alleged and whether it rises to defamation. And if you look at it in its entire context, isn't the gravamen really about the threat to kill as opposed to any of the other actions?
Well, you know, I think we can look just generally at the gravamen, but I think in terms of a standard that we would be able to apply to this in subsequent cases, that's not something that Lieberman actually discussed, but subsequent cases have looked at an applicable standard, and that's the standard that was set forth in the Restatement Second, Section 571. And under that standard, you do look at whether or not the conduct would be punishable by imprisonment in a state or federal institution or regarded as a crime involving moral turpitude. And in this situation, the alleged acts would subject the plaintiff appellants to imprisonment in a state or in a federal institution if they were to be true. We cited 3 statutes that the plaintiffs could be subject to and charged with, and those are serious crimes. And so we think that
It's not inconsistent with Lieberman, which said harassment, which could end up in jail time, is not a serious crime. So it's not just imprisonment. Obviously, that's the parameter.
Well, yeah, look at the whole context, including whether or not it's alleged to have taken place on federal property, and look at the penalties involved.
We'll have some time for rebuttal. Are you the co-appellant?
We have a separate appeal. I represent Local 3369.
Okay.
Would you like to hear my appeal after?
No, you should go, but you probably should have sat there, but it doesn't matter. As a cross appellant, you should have probably sat in that seat, but it's the end of the day, we can be informal.
Apologies.
No problem.
Good afternoon, Your Honors. My name is Lane Armstrong, and I represent Defendant, Respondent, Appellant, Local 3369. We are here because we believe that the trial court improvidently exercised its discretion when it refused to consider the local's late motion for summary judgment, and we're asking this court to grant summary judgment de novo. As Your Honors are probably well aware, CPLR 3212 gives the court discretion to permit late summary judgment motions, and the Court of Appeals has defined what would be good cause for permitting a late motion in Brill versus City of New York. It's 2 NY3D 648 in 2004.
Well, when you brought your summary judgment motion, the note of issue wasn't filed yet, right?
Correct.
You
And
still had a discovery motion pending, a motion for protective order pending at that time, right?
yes, Your Honor. The note of issue had not been filed. There was a discovery motion pending for many emails that the local had claimed privilege over, but that plaintiffs...
All that would support your good cause argument.
Correct. Yes, Your Honor. In addition, there
was no employer-employee relationship between the local and the defendant, Garces. I'm not sure I'm pronouncing his name right.
I believe that's correct. No.
So in other words, he was duly elected. They really have no say. I mean, the union can't just unilaterally throw him out or get rid of him, right?
Correct, Your Honor. There's an internal process that must be followed. There's a national union that had the power to remove him temporarily, but this was the will of the members. The members voted for Garces, and he was, I believe he was vice president as an elected official, and then through the internal process had stepped in as the president when the president left. So no, there was not an employee-employer relationship, which is one of the bases that we sought summary judgment in this case. And also, Your Honor, we believe that the negligence torts were an attempt to get around Martin v. Kern, which, as this panel I'm sure is well aware, has been affirmed several times. And Martin v. Kern says that any action of a union that's not ratified by all of its members, intentional torts and breach of contract and some other causes of action, cannot be sustained against the union itself. So in this case, we believe that the pleading of these negligence causes of actions, which really do not fit, there's the negligent hiring and retention, and then just a general cause of action for negligence, which may or may not have been premises liability, were brought in order to bring the local in to the case when in fact there are no real claims against the local. And since its summary judgment is purely on a legal basis, we believe that it was appropriate here. And we would ask the panel to grant summary judgment. If there are no other questions at this point, I will wait for rebuttal.
Thank you.
Good afternoon. Dan Nesbitt with the law firm Cohen, Weiss & Simon, LLP, on behalf of defendant respondent. The trial court dismissed plaintiffs' defamation per se claims because plaintiffs were not accused of committing a serious crime. That decision was correct, and this court should affirm. The primary conduct in the challenge statements, as the panel noted, is that plaintiffs were accused of threatening to kill Garces and threatening to physically harm Garces on federal property.
And so why did Mr. Garces make that reference in the March 27-17 letters to both Mr. Riordan and Mr. Bigelow, that the threats occurred on federal property?
He made that reference because prior to the threats occurring, there was a union meeting at a federal building, and the threats happened outside of the building on the adjacent sidewalk. And so that was the reason that Mr. Garces referenced or included the on federal property language in his letters.
So that I'm clear, nothing took place in the building?
There was, so the way the incident unfolded is that Garces was leaving a meeting inside of the building and saw the plaintiffs inside of the building. While inside of the building, the plaintiffs raised their voices and invaded his personal space, but the threat on Mr. Garces' life did not occur until they were outside of the building on the sidewalk. And plaintiffs argue that the fact that the threat was made on federal property distinguishes Lieberman, which is otherwise binding and controlling precedent, because there are 3 federal statutes that plaintiffs were allegedly accused of violating. That argument's unavailing. The main federal statute that plaintiffs rely on is 18 U.S.C. Section 111. Section 111 doesn't apply here. Section 111 applies when someone interferes with a federal employee while that employee is engaged in their official duties. Here, as the trial court noted below, the statements make plain that the conduct occurred after a union meeting while Mr. Garces was acting in his capacity as local union president, not in his capacity as a federal employee. And so because the conduct wasn't interfering with Mr. Garces' official duties, Section 111 does not apply.
So what about Section 113?
So on Section 113, Garces' position is that even assuming that Section 113, that plaintiffs were accused of violating Section 113, that wouldn't be a serious crime in these circumstances. And the reason for that is the clarity with which the accused conduct here is not a serious crime under New York law, And just to briefly cover that, the threat to kill under Lieberman is second-degree harassment, which imposes only minimal harm on a plaintiff's reputation, and so is not defamatory per se. The only other specific conduct identified in the statements is that plaintiff Riordan, not plaintiff Bigelow, just plaintiff Riordan, spilled or got saliva on Mr. Garces' jacket or the side of his face. Even assuming that spilling saliva is equivalent to intentionally spitting on someone, spitting is prosecuted also as second-degree harassment. A good case for that is People v. Simmons, 976 NYS 2D 835. And so because under New York law, it's very clear that threatening someone's life and spilling saliva on them is not a serious crime. The only difference—
Of course, colloquially, we always say we don't want to make a federal crime out of it, right? Or a federal offense out of it. And isn't the federal offense in Section 113 a little bit different, have a little more criminal oomph than our harassment statute, which is a mere violation?
So we think that given the clarity with which New York law speaks to this, the only factual difference here is that plaintiffs were alleged to have engaged in this conduct on federal property, but a reasonable listener would not change their view of the way in which a statement impacts the plaintiff's reputation solely by the location of the conduct. Rather, a reasonable listener makes that determination based on the conduct itself. And there simply is no meaningful distinction between threatening someone's life outside an apartment building, which is what happened in Lieberman, and threatening someone's life outside a Social Security building, which just so happens to be a federal building, which is the case here. And so we submit that Lieberman is binding authority, and for those reasons that the decision below should be affirmed. If there's other questions, I'm happy to answer them.
Any other questions? Okay, thank you very much.
I do want to touch upon the point that the statements made by Mr. Garces, he said that the alleged interaction, threat, he said that it took place on federal property for a reason. And he knew how serious that charge would be. He knew that that the threat did not, in fact, take place on federal property, but he said that it took place on federal property anyways. And the reason he did that was because of the fact that listeners, when they hear of a potential federal crime, they think that it's serious. They understand it to involve federal authorities, and that was Mr. Garces' intent.
Well, I think when my learned colleague posed the question to your adversary in the context of this so-called serious crime, would a reasonable listener hearing this say, oh, he threatened to kill me in the Federal Plaza building. He threatened to kill me outside my apartment building. He threatened to kill me in the subway. I'm giving you different places. Would that reasonable listener suddenly say, oh my God, he's charged with a serious crime if the heart of each of these statements is threatened to kill, which is harassment, and not the place where the statements were made? Would someone suddenly think, oh, this is a serious crime because of where those statements were made? That's a key distinction here.
I do think the context matters. There's a difference between he threatened to kill me when he was drunk at a bar versus he threatened to kill me at a federal courthouse.
This was a meeting. This was a union meeting that was allowed to take place on federal property, which is fine. You're allowed to have a union meeting on federal property, and there's no dispute that that's what was taking place here. It could take place in a bar too. It could take place in an auditorium, wherever you want it. The question is, does it become a serious crime implicating the federal statute just because of where it is, even though it remains the same? The same threat is a constant. Again, as was pointed out, a reasonable listener, would that reasonable listener suddenly say, oh my God, this is serious because it took place on federal property versus a bar, an apartment house, or wherever else?
I think it does create an idea of more seriousness when it takes place on federal property. And I would just, as a last point, refer the court to the November versus Time case, where the Court of Appeals said that the court should not strain to interpret a defamatory statement in the mildest and most inoffensive sense. And in this situation, I would submit that a listener could view that statement as charging the plaintiffs with a serious crime.
Thank you very much. You have 2 minutes. Your co-counsel. No, not you, your co-counsel, I'm sorry.
Thank you, Your Honors. Unless anybody has any questions, I will rest on our briefs.
Any questions? Okay, thank you very much.
Thank you.